Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. That is the Columbia River right back there. Around the bend is actually the Gorge Amphitheater. We're going to be heading there for day 3 of Watershed. But today, I want to talk to you about some very forward thinking that comes from a state that candidly does not get very well known for its forward thinking. It's an issue that we've been very consistently speaking on this channel, and it has to deal with those who have medicinal marijuana needs and also want to enjoy their Second Amendment rights. Today I'm going to talk to you about a state that I think has really figured out the perfect balance on how to protect medical privacy and the right of self-preservation. So today, let's spend a few minutes and let's talk about why isn't every state doing what Arkansas is doing? Okay, so once again, coming to you from the beautiful Columbia River Gorge. Now listen, we're talking about Arkansas House Bill 1784. Didn't get a lot of publicity, actually kicked through the legislative session about a month and a half ago, and actually was passed out of both the House and Senate with overwhelming numbers, signed into law then by Governor Huckabee Sanders of the great state of Arkansas, and actually went into effect August 1st. Now here's what the law does, and this is a really, really important issue, okay? What the law states in the state of Arkansas is that if you are a medicinal marijuana patient, that is, you have state authorization from a physician to use cannabis, none of that information can be used to deny you a concealed carry license, and the Department of Health, that is the Arkansas Department of Health, cannot disclose that information to anybody. The statute specifically reads, the director shall not consider a person's status as a qualifying patient or designated caregiver under the Arkansas Medical Marijuana Amendment of 2016, Arkansas Constitution Amendment 98, Section 2, in determining whether an applicant is eligible to be issued a license to carry a concealed handgun under this subchapter. And then the law further states, an applicant shall not be considered to chronically or habitually abuse a controlled substance based solely on the applicant's status as a qualified patient or designated caregiver under the Arkansas Medical Marijuana Amendment of 2016 or the Arkansas Constitution Amendment 98. So this is huge because we know under 18 United States Code Section 922 that any person who is a user or an addict of any controlled substance as defined by federal law is ineligible to possess a firearm. Now, does this law solve that problem for everyone in Arkansas? No, it doesn't. You still have this big federal law hanging over your head, but does it allow the state of Arkansas to more adequately protect the rights of its citizens? It most certainly does. Until 18 U.S.C. Section 922 is amended, or until we just simply remove cannabis from the schedule it's currently on and put it on the same schedule as alcohol and tobacco. Unfortunately, that might allow the ATF to start regulating that as well. But those are the only two solutions to that problem: legalization of cannabis or a complete amendment of 18 United States Code Section 922. Now, Arkansas's new law goes on to further then limit the Department of Health from being able to disseminate any of this data for any other purpose. The law specifically now reads, the Department of Health shall not disclose the identity of a person who has been issued a registry identification card to the Division of the Arkansas State Police for the purpose of facilitating a criminal history record check or any other background check related to the issuance of a license to carry a concealed handgun. And the law also has restrictions placed directly on law enforcement, as it reads, the director of the Division of Arkansas State Police shall not consider a person's status as a qualifying patient or designated caregiver under the Arkansas Medical Marijuana Amendment of 2016 in determining whether an applicant or licensee is eligible to be issued a license to carry a concealed handgun under Section 5-73-301. Listen, I applaud the state of Arkansas for what they've done. We have done multiple videos, including a lawsuit that was brought in Florida by then Agricultural Secretary Nikki Fried. The bottom line is this, is that there is no debating that cannabis does have medicinal purposes, and many individuals have resorted to it for legitimate medical treatment. When you consider the opiate epidemic that this country has suffered through for decades now, and the fact that cannabis can also be used for pain management. There is very little argument as to why there shouldn't be some effective treatment and some people who can effectively be treated by cannabis. However, when we allow these people to access medicinal marijuana, there is a database now that absolutely positively makes them ineligible to possess a firearm on a federal level and on many state levels as well. What it does is it puts the person in the Hobson's choice of either going out and getting the proper medical care or otherwise being able to exercise an inalienable right. I applaud the state of Arkansas for what they did. I applaud the state legislature. I applaud the governor for signing this into legislation, and I encourage every other state to do exactly what Arkansas has done. Listen, you may have more questions about this or anything else related to your Second Amendment rights. Now, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. In the meantime, I do want you to remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From the beautiful Columbia River here in the middle of Washington State, thanks for watching. Stay safe.